Welcome to Landlord Coffee Talk, Episode 6, brought to you by Sean Sharvetchian's office at the Southern California Apartment Group. Today, we're launching into a quick-fire Q&A session tackling inquiries from landlords regarding issues with their current tenants and the criteria for eviction. Joining us is our landlord and eviction specialist, attorney Anthony Marinaccio. Hey, Anthony.
Good morning. How are you?
I'm doing fantastic.
Great.
How are you?
Good.
Thanks so much for joining us today. The reason why we have you here is we hear these questions often in our office, and what better ways to invite you over and be able to broadcast this to the rest of our landlords out there viewing today. First question in our fire round is Ani from Van Nuys. Ani's asking, my tenant has paid rent late for the past 5 months. Despite her rent being due on the 1st, she consistently pays after the 6th, resulting in late fees accumulating over this period. As per the terms of her lease agreement, she has accrued a total of $250 balance at a rate of $50 per month. Despite repeated reminders, she refuses to settle these late fees. Am I within my rights to initiate eviction proceedings due to her outstanding balance?
So generally, you cannot evict for late fees. You could try to serve a 3-day notice to perform or quit based on the amount of late fees that are due. However, the eviction probably would not proceed as well because late fees would be considered liquidated damages and required to be separately negotiated and in the lease agreement to be initialed. And so generally most landlords don't do that, so they probably would not constitute a valid reason for an eviction.
I see. So interesting. Lease agreement for the late fee part to be initialed would help the landlord later down the line.
Exactly.
Okay. So that's a good point to bring up. And to stay proactive, Ani should, instead of sending repeated reminders, should serve a 3-day notice to pay or quit for the late fees?
Correct. So generally most leases, the way they're written is there's a date that the rent is due, which would be the 1st of the month, and then if there's a late fee, it would be incurred after the 5th of the month.
Got it.
However, rent is still due on the 1st, and you could serve a 3-day notice to perform or quit on the 2nd or 3rd to ensure payment.
Okay. All right. But in your experience, late fees really haven't gone through so much for evictions.
Correct.
Okay. Understood. George from Montebello is asking, my tenant unexpectedly relocated to Mexico without notifying me and handed the keys to his sister. I recently discovered that his sister and her family have been occupying the unit for the past 3 months, paying rent. However, there's no lease agreement on file for them. I'm unfamiliar with who this individual is and who her family is. Given these circumstances, can I pursue eviction despite unknowingly collecting 3 months' rent from them?
That would be a difficult eviction for a few reasons. One is you've accepted rent, even if you did not realize who it was coming from. If it came from a separate name, that would probably give you enough reason to believe that another person was living there.
Right.
The biggest issue, though, is without a written rental agreement, there's no violation of a rental agreement.
Mm-hmm.
And so actually, even though you may have rented to person A, at this point, person B is living there without a rental agreement, but person A was never living there with the rental, was always living there with the rental agreement. So it would be a difficult eviction. It's possible, but it would just be, there could be lots of different defenses.
Got it. To stay proactive, you may want to get a new rental agreement in place.
You could definitely ask the tenant that has moved in, the new person, to try to get to them to sign a new lease agreement.
And if they refuse to?
Depending on where you're located, it could be an issue. It just depends on what city you're in.
I understand. And as far as the rental amount, would that reset to the market rents that you're able to charge?
The issue here would be that a landlord had been accepting the 3 months rent.
I understand. Got it. This takes us to Abraham from Glendora. He's asking, my tenant has a new dog. My building is a no pet policy building. Can this be grounds for eviction?
Yes. In most jurisdictions, it can be. However, the rental agreement itself has to state that there is a no pets policy, not the building itself. However, in my opinion, many tenants, when they find out about the issue of a pet not being authorized, they may perhaps turn around and give you documentation showing that it's an emotional support animal, which would be a reasonable accommodation that you cannot evict that person for
Okay.
having that emotional support animal.
Now, can you go as far as asking for the right paperwork to determine that it's an emotional support animal?
You can ask for the valid paperwork from a doctor, for example, a doctor's note.
A doctor's note, understood. Abraham again from Glendale says, my other tenant, I have a no smoking policy per the lease. My building is a no smoking allowed building, even in the common areas. Tenant keeps smoking on the common grounds of the building. My tenant upstairs is complaining of the smoke smell. Is this grounds for eviction?
Yes, it could be. If you do have a tenant or neighbor complaining and a witness that is going to testify that would say that the person is smoking in the building, and it's a violation of the rental agreement. There are also some cities, I know Glendale is one of them, that has a no smoking ordinance that does prohibit smoking so far away, within so many feet of a building.
I understand. Next question is Art from East Los Angeles. A tenant in one of my units was involved in a physical altercation with the tenant living upstairs, which resulted in a police report being filed. In light of this incident, am I legally able to initiate eviction proceedings against the tenant who committed the assault?
If there was an assault committed on the property against another tenant, yes. However, the victim, the tenant that was beat up, would actually have to be a witness and testify against the other tenant.
Okay.
And as long as there's an agreement to do that, it could proceed as an eviction.
I understand. This client of ours wants to remain anonymous. The unit was initially leased to 3 roommates. When one roommate left, the remaining 2 roommates took it upon themselves to seek out a replacement without my authorization. Could this action justify eviction?
If the rental agreement has the 3 persons spelled out and named, and those are the only 3 people that are supposed to live there, then yes, you could proceed because they are violating the rental agreement by having another person there.
Okay, understood. Fred from Glendale, how long, in your experience, does an eviction process for non-payment of rent take from start to finish?
The average eviction in Los Angeles County is taking about 12 to 16 weeks, which is about 3 to 4 months.
Okay.
And that is from the time of filing the complaint to the time of a sheriff's lockout.
Understood. And I'm assuming adding another month to that with you issuing a notice to pay or quit?
The pay or quit takes only a few days,
Okay.
so maybe another week.
Another week to that. All right. Fred again from Glendale. How long does an eviction process take for a violation of lease? Like, for example, having a pet in the unit that's unauthorized.
Same amount of time, 12 to 16 weeks, so about 3 to 4 months.
Mm-hmm.
That's an average amount because a lot of times if a tenant demands a jury trial or there's other issues related to the unlawful detainer, they can go longer.
Mm-hmm.
I've had cases going 6 to 7 to 8 months.
Mm.
But even a default has taken about at least 12 weeks at this point
Okay.
to get the sheriff's lockout.
Yikes, so 12 weeks, 18 weeks. So with that said and all that taken into consideration, including the attorneys that are hired in this process, Fred is also asking how much on average does an eviction cost?
It really depends on what happens in the case itself. Default, you're looking at probably less than $3,000. If there requires additional court time, it just depends on how often we go to court. And if there's a jury demand or not, jury trials can be expensive. They take even the shortest unlawful detainer jury trial will take at least 3 days. So that's where a lot of the costs get incurred.
I see. Okay. Anne Marie from Covina. I have a sheriff lockout date scheduled 3 weeks from now. Am I obligated to assist with relocation costs for this tenant?
If you've already gotten to the point of a sheriff's lockout, you've already have a judgment against this person. And so no, you would not have to pay relocation at that point. At that point, just wait for the sheriff's department to show up to do the lockout.
Okay. Jennifer from West Covina. I have an 8-unit property. I'm renovating my house and I need to live in one of my units until my project is complete on my own home. Can I evict my tenant, the one downstairs with the garage, and occupy my own unit?
Now, I know as an attorney, no one likes this answer, but it depends. It depends on where you are, what city you're in. There are a lot of statutes that allow for owner-occupancy. However, even under the state law, it does require a minimum amount of time that you will stay there. And in some places like City of LA, it's 2 years.
Okay.
And so as long as you're going to stay there for long enough, there's certain other requirements are required. You would be able to go there and occupy the unit. Just depends on how long you plan to stay there. If it's only for a very short time, let's say 2 to 3 months, there's not even under state law would you be allowed to do that.
I understand. Now, I want, she was saying, because we were chatting with her over the phone, and she was saying, I want that one particular unit, though. That's going to be best for my family. It's got a garage, it's got a living room. That's sort of like the owner-occupied unit that I'd like to have. But she's said that the tenant in there is over the age of 65, and she wasn't sure if there's any laws against removing a specific individual.
So, for example, in the City of LA, there are certain restrictions as to if the tenant is disabled or if the tenant is over a certain age, and whether or not that person is terminally ill and how long that person has been there.
Mm-hmm.
There's lots of requirements and lots of exceptions to those requirements. Also, for example, City of LA, which is where a lot of landlords have buildings, generally you can only evict the most recent tenant of the similar units. So for example, if you have a 5-unit building and all 5 units are 2 bedrooms, you have to go with the person that has lived there the shortest amount of time, which generally is the person that pays the highest rent.
Right. All right, wow. Well, I'm going to cap it off at Jennifer from West Covina. Amazing information again, Anthony, and thank you for taking the time for meeting us today.
Thank you.
Awesome. These are just a few of many questions we get. The good news is that we have a dedicated text hotline where you can send in your questions. Our team guarantees a response within 24 hours, and one of our experts will be available to provide you with advice. So if you have any questions or need further insights, don't hesitate to reach out through our text hotline at 626-657-9547. You can find our contact information in the description below, and we are here to assist you.